Welcome to Legal Minds. My name is Samson Mando. Today, we're diving in the sphere of criminal law. Now, we're going to discuss crime, what is a crime, and the elements of a crime, and what constitutes a crime. So, the crime differs. It depends on the place, the jurisdiction, and time. It changes from time to time. What used to be a crime in the 18th century is not a crime in the 20th century. What is a crime? What is considered to be a criminal offense in America? It's not a crime in Zambia. So what I was saying, criminal lawyers and criminologists have failed to give a precise definition of a crime. However, academics have provided an insightful definition for a crime. And it was established in the case of Board of Trade versus Owen. In that case, they defined a crime as unlawful act or default that is considered to be an offense against the general. So as I was saying, a crime is an unlawful act or default that is considered to be an offense against the general public or a society as a whole. It renders the person who is guilty to legal punishment as a legal requirement. So, from this definition, we are able to get the elements or which constitutes a crime. We're saying it is an unlawful act or default. The second, we're saying it is considered to be an offense against the general public. And the convicted person suffers some sort of punishment as a legal requirement. Now, what are the elements of a crime? The elements of a crime, we have actus reus, mens rea, concurrence, causation. However, today we are going to look at actus reus as an element of a crime. Now, before we look at that, crimes are divided, are categorized. They are what we call conduct crimes and result crimes. Conduct crimes, this is where the defendant's actions or the defendant's conduct is prohibited by law, is a prohibited conduct. So, the actus reus is a prohibited conduct when it comes to conduct reus, to conduct crimes. For example, I can give you an example. Dangerous driving. All that needs to be proved by the prosecution is that the defendant was driving a mechanically propelled vehicle in a public road or public place. They do not need to prove that due to that conduct it resulted into harm or injury. No. All that needs to be proved is that he was driving a mechanically propelled vehicle. Now, what about result crimes? Result crimes, this is where the defendant's actions results into a prohibited consequence. So the consequence is prohibited. For example, murder. The actus reus for the offense of murder is that the defendant's act should cause death within 1 year, 1 day. So, where that person has not died within 1 year, 1 day, they have not proven the actus reus. So let's now talk about the elements of actus reus, or actus reus as an element of the crime. Actus reus, this is a Latin terminology which means guilt act. It is the blameworthy conduct. It is a prohibited conduct. So, the first element for actus reus is that actus reus must be voluntary. If the defendant's conduct is not voluntary, he may not be liable. He will not be criminally liable. Now, there are three instances where actus reus is not voluntary. Automatism. This is where the defendant's conduct is beyond his control due to some external factors. Here we apply the case of Ara versus Quick. This is a landmark case in criminal law, colleagues. You have to look it up. So in this case, the defendant was suffering to a medical condition called hypoglycemia, where a person can be unconscious but yet awake. So due to this condition he was suffering, he assaulted someone while in an unconscious state, and he was prosecuted. But the Court of Appeal held that the defendant's conduct was not blameworthy, as he had no control over his action due to some external factor. And the external factor here was that the intake of insulin, that was the external factor. What is the second circumstance where actus reus is not voluntary? Duress, where a person is coerced or forced to commit a crime. The defendant won't be liable. Now, the threat should be a physical threat, not an economic threat. On this one, for example, where a person where a motorist hits a driver, another vehicle, let's say a motorist hits another vehicle, and that other vehicle maybe hits a pedestrian. That means the driver who hits the pedestrian, he was forced. It was not a voluntary act. There, the driver won't be liable. The third instance is reflex action. It is spontaneous reaction to a stimulus, where the defendant's conduct is beyond his control. We have an interesting case on this point that I need you to look at. The case is Hill versus Baxter, a 1958 case. It's a good case. It explains what reflex action is. So now, what is the other element of actus reus? Actus reus must be an act, not necessarily an omission. So the general rule is that actus reus must be an act. Now they are giving us an exception. The law provides for exceptions where an omission can be considered to be as an actus reus. Now there are instances where an omission, or where the law has established a legal duty. The first instance is common law duty of reliance. The case of Ara versus Stonehouse